Hello, good afternoon, good morning, good evening, wherever you are. This is Sami I reporting. Wherever you're listening, please subscribe to this channel. It's a channel basically dealing with everything African intellectual property jurisprudence like. Today I'm going to be talking about a subject that I've been on for a while now, the subject of AI and law schools curriculum in the era of artificial intelligence. Today's talk, I would subtitle it or title it AI, Artificial Intelligence, and Sustaining Legal Education for Creative Originality in African Law Schools, African Colleges of Laws, African Faculty of Laws in the universities. So, there's been lots of recent research survey done on the impact of artificial intelligence on aspects of training of lawyers in the law schools, referring to the area of legal writing, which is a fundamental course subject in the training of lawyers and even after law school, becoming a professional practitioner either in the advocacy area or transactional area or any field, public service as a lawyer. You have to be a good writer, legal writer, because also that lays a good foundation for you to speak legally, speak efficiently, legally, and effectively, excellently as a lawyer. So a lawyer has to be good in his or writing and also speak effectively, legally, laying out his or her point in organic analytical fashion, like I spoke recently in Washington, that there is a method to legal writing madness. There's a procedure about writing that we have to conform with. So, what I'm going to do now is to go straight ahead and let us know the significance of legal writing for lawyers. You see, ordinarily, as a lawyer, you have to be good. You have to know how to write properly. You have to also be able also to be deep in your critical, analytical laying out of your points, your legal points, in any area you find yourself, whether in the commercial field, the public field, or non-public or non-commercial field. So AI has thrown up a lot of complexities because of the powers of the generative programs of AI, the large language models that are so efficient now. They are close to acting like thinking and doing things like humans. So they basically, from my experience, because this talk is a product of years of teaching in law schools in about 4 continents, I have noticed that law students are becoming lazy, and there's a vacuum because law schools are not paying more attention into rising up to bridge that gap that the generative AI's program like ChatGPT, Grammarly, DeepSeek, a lot of them out there now, assisting students a lot. They rely a lot on them because I did a survey recently from the papers I got from students, written assignments, legal assignments, and I discovered that more than 80% of the class, of about 90% of the class, about 87% of the papers, you're running them through AI check using another AI system, and also not just AI, using my knowledge of the subject, because I don't just rely on the AI check programs. I also have to, because at times knowing that AI can they can be faulty, you also have to check to see whether the student actually relied on a machine. And at the end of it, I agreed with the AI check. There was a lot of copy and pasting by students, from most of them used chat. It was, I think, 50-50, chat GPT and Grammarly. Rely a lot on them substantively in their write-ups, in their legal assignments. I mean, real life, subject classroom assignment. So these are the problems we are facing now. However, my concern now is that we are having a problem. There is a contention between ethics and also law, the law being intellectual property laws. The ethics means the issue of, which has always been the traditional thing in academia, plagiarism, where you taking a work from somebody else without attribution. But it's bigger now than the issue of just plagiarism, because law demands positive action, and AI and IP are coming into collision because IP laws, intellectual property laws like copyright and patent, demands that even though you acknowledge, especially copyright, the areas of the narrow confines of exceptions of copyright allows you to actually, copy or take from an existing work to create a new work, derivative creativity. It's allowed. It falls under the fair use doctrine or the fair dealing, depending on the jurisdiction you are in. Most of the African countries prefer to call it fair dealing. In the North American area, they call it fair use. And so there is the demand, the responsibility that is required of law students and lawyers, apart from the laws of IP that demands that you don't infringe on people's work, literary work, which is legal writing, the assignments you write, the research you do, and the outcome of the research is going to be ends up in a work product in the form of a paper or in the form of invention, which is covered by patent. So the IP laws demands that when you attain a certain level of eligibility, if using copyright now, one of the grounds for your work to be given that protection that grants you a lot of rights, economic rights, social rights, utilitarian rights, is that your work has to be original. Your works has to be on a tangible platform. Your work has to be an expressive, not an idea. It has to be in expressive form, which is what copyright actually concerns itself with. There are other IP laws that deals with ideas. I think that comes within areas of patent. So you see the conundrum that law students have found themselves or have been thrown into with the generative AI programs is that if you totally depend on typing the question into that chat box and takes everything, for instance, ChatGPT tells you about, or what, for example, there is an assignment that is from your boss or from your professor. What is a dog? DOG, or what is the meaning of dicta? DICTA. You just go and type it, and of course, because the good thing about LLMs, the large language models, is they've been trained on so many data sets, and now they can virtually tell you, because they have all sorts of information from everywhere. Within a second or two, they can give you the answer from your perspective of what a dicta is. And what you do, which is what most humans do, you don't want to work too hard. We are living in a microwave age. The digital era is more like a microwave, a micro, where we just put in things there within a second. It's done for us. So you now churn out the answer from your prompt and paste it in your own document. Voila, you send it to your boss or your professor. That's your answer. The problem with that as a lawyer is that there is another rule that governs your profession, which is embedded mostly in the code that is mostly titled in some places the rules of professional conduct, the code of professional conduct for lawyers. Almost all the countries I have been to, I think it's universal. Everybody has a kind of a uniform rules of professional conduct, the code. In Saudi, there is a law. It's a positive law. In Nigeria, it is. In Ethiopia, it is a law that it governs. Which there are rules that concerns candor, rules that concerns competency. You have to be competent in your subject to advise a client. There are rules that of modesty. There are rules of against deceit, so to say. So now, if you depend solely on ChatGPT, I'm using ChatGPT now as an example of a large language model, LLM, which we use these days. So you see that you might fall into the trap, because first of all, you won't tell. A lot of the students don't even tell us the sources. There was a case, I gave a student an assignment about labor law, strictly labor law. It was in a form of a memorandum, trying to see the practical, how much they know about how to write a memorandum, a legal memorandum on a subject. So I crafted a problem that involves, the central question was governed by labor law, this between a journalist and his employers, a journalist who was who published a book on the side while he was still employed by, it created a scenario of kind of conflict of interest, So, this student, the first two sentences I read was fiduciary. I saw the word fiduciary. And I knew at that stage I had not taught them anything close to insurance, anything that, centered on fiduciary issues in terms of law. And, at our level, as a teacher, you would know how much a student, even if it's one of the top 1% of your class, you would basically know when a student is far off where you are. We've not gone. So I kind of like, okay, come to my office, let's talk. This question is not about anything fiduciary. What relationship? This is a strict master servant in the whole colloquium. This is a question of labor, rules. Was the conduct of the journalist is a breach of the agreement he had with his employers, publishing a book, a student book. It was a book about young kids. Did it conflict with the contract he had with? Because the subject also referred to the primary contract that governed both parties. So I knew right then, before I even put it on AI check, that this is not the work product from a student. It was from some other sources. So by the time I put it in the AI check, voila, it was from a different source. And so, you see, these are kind of issues, and the student was so vehement that it was his work product. The students was really, really affirmative that this is my work product. I did this. Yes, you did it. There's no doubt about that. You gave the prompt. You took it from one source and pasted it in another source, and voila, send it to your boss or your professor as your work. But in law, that is not as a professional. The law demands more from you. Apart from the rules on attribution, you have to tell us where you got your sources from. There's also the candor, the misconduct you may have committed as a practitioner, as a licensed lawyer, if you want to be practitioner, even as a scholar. So now you could have infringed on where you took the work from. Now there's Saudi Arabia as a country is confronting this issue in its own way. Probably there is now there was a policy directive that was out there for comment. The country is also trying to confront this issue of dealing with a society that should not be solely dependent on the prompt of the machine. So Saudi Arabia, under this new policy, the Saudi Arabian National Policy on Scientific Integrity and Research Ethics, Articles 4 and 8 of the proposed policy, I'm going to summarize it now. The National Policy on Scientific Integrity and Research Ethics demands that if AI content, I'm quoting directly from the policy, under Articles 4 and 8, there is a subsection there that says, if AI generated content exceeds 20% of the total work or any individual section, it may be a violation of the scientific integrity. This is a good start. Although I would extend the argument by saying that, the fact is that the objective here is to limit how much is to attack the issue, the substantiality, or the amount of content you should depend on from the LLMs, from AI. But also putting a figure of 20%, 1%, 5% on it could also be a problem, because so if I rely on 20% from AI, it could be the core. What I'm relying from AI could actually be the core of where I'm copying it from. It could be, so you see, it could have a negative or a corollary situation with copyright law or other IP laws, but I'm sticking here with copyright law particularly, because that 20% could actually be a copyright infringement. From the InfoPack case, where the court of the court in European Union decided the issue of the substance to be copied. So we should rather, yes, we could put a percentage, but we should also add that where the work copied, where the work AI work relied on, is the core of what you are writing about, there should be need for hearing the voice of the copier, meaning that if you are um, depending on AI generated content, if that content is even below 20%, that 20% should be your own input. There should be something about your voice from what AI has generated. So whether it's less than 20 or more than 20%, we should be more focused on the substance of what AI program has generated and has been relied upon by the author of the work. So that is what Saudi Arabia is doing, is planning doing right now. And we will see that in the laws, the current jurisprudence, the laws in most of the African countries we have, Nigeria, Ghana, recognizes Ethiopia. South Africa recognizes AI as a computer program, which is a literary work, which also is within the purview of copyright protection. So AI programs themselves are regulated by copyright. The benefits, the mischief, the benefits, the values attached to AI programs are derived mostly from copyright laws. What do I mean by that? What I mean is that now, if your work attains the stretched threshold of being protected by copyright, there is a societal benefit attached to that work. That work might you have exclusivity. For instance, nobody can copy your work and use it for any commercial gain without getting your permission, except within the narrow confines, because there are certain work can be used under the fair use doctrine, like I said. The exceptions, or called in Nigeria and most of African countries, like I said, fair dealing. So, but generally and fundamentally too, because this is an area where the AI enthusiasts are hanging on, that most of the AI work are fair use, are protected, are exempted from copyright protection. Even the AI companies now, the Open AI presidents, Sam Altman and the rest, a lot of them now are in the forefront of lobbying for artificial intelligence to be exempted from copyright protection or from intellectual property laws themselves, which is going to be a big fight from academics like me and some other people who value that IP is still relevant for modern economy, especially for developing economies who are now waking up to the benefits of using intellectual property regimes in augmenting and in enhancing their economies. So that's the story for another day. We will look at those areas where people who are looking for ways to undercut the global economies, especially economies from global south, by saying we should suspend intellectual property laws when it has to do with AI, because AI is so ultra utilitarian. The value of artificial intelligence it far exceeds the economic value that IP laws would bring to owners of IP. Well, let's see how that goes from here. But we know that recently the Court of Appeal in the United States, in the District of Columbia, has kind of laid to rest for now that copyright does not avail AI. Only it avails human person. So it's only human authors that have the benefit of being protected by copyright laws. And to a certain extent, it therefore means that works that artificial intelligence creates are not copyrightable, so to say. There are other nuances to this topic. We will deal with them in a later date, but I just wanted to discuss this issue of making sure that the law schools in Africa, in the global south, start addressing the balance that we need to teach our law students on how to navigate the AI systems and actual legal writing, to not fall below the standard demanded of lawyers, because as this is a profession that requires a lot from human intervention, your thinking, your advisory work, your intervention in disputes, should not be solely dependent on what the machine says. Yes, there is a benefit to, especially in terms of research and the wide field of congregating knowledge, but we should not solely depend on machines. So that is where we're gonna do it. How we're gonna do it today from some AI reporting. I thank you for listening. Please subscribe. Click the subscribe button there. Till we come again. My name is